This is Bart Peterson, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Greg Gilchrist, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Dan DeMarco, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
Hello, everyone. This is Tom Fox. I'd like to welcome you to the FCPA Compliance Report on the Compliance Podcast Network. Today, I have back with me Morrison and Foerster partner James Koukios, certainly a FCPA Compliance Report podcast favorite. In this episode, we take a look at the firm's always excellent anti-corruption newsletter, the top 10 developments in international anti-corruption for March. We take a look at the MTS Settlement, changes in the FCPA Corporate Enforcement Policy on De-Confliction and ephemeral messaging, the OECD Working Group on Bribery reports on the UK Foreign Bribery Enforcement Record, CFTC entry into FCPA enforcement, and we conclude with a look at India, which appointed its first anti-corruption ombudsman. It's a fascinating exploration and always great conversation with James Koukios, one of the top white-collar defense lawyers, former DOJer in the FCPA unit. I know you will enjoy it. Thanks for listening. The FCPA Compliance Report is a production of the Compliance Podcast Network and a proud member of C-Suite Radio. Hello, everyone. This is Tom Fox back for another episode, and today we have back with us fan favorite James Koukios, partner at Morrison and Foerster. James, welcome back.
Thanks, Tom.
James, as is our wont, we take up the Morrison and Foerster top 10 international anti-corruption developments. This episode, we're going to take up the newsletter for March. So with that, really, what struck me about March, as well noted in your newsletter from the FCPA enforcement world, was the MTS settlement. So I just read a lot into this. It seemed to me a very bad set of facts with a very, very bad set of actors in a very bad place with a very bad foreign government official. So I don't know if you agree or disagree with that assessment, but from where you sit, what did you see about the MTS settlement?
That's a pretty concise description, Tom. I think you hit it. Well, this, of course, is part of a much bigger case. This is the third telecommunications company to resolve allegations regarding alleged bribes to the daughter of the former Uzbek president in order to gain access to the Uzbek telecom market. And so the allegations are that it's a little unclear exactly what her position was. She was the daughter of the president. She did have some other positions as well, but for some reason she was able to have quite a bit of influence over the Uzbek telecom market. So she required, allegedly, these companies, including MTS, but a couple others, TeliaSonera and Vimpelcom, to pay bribes in order to get the licenses to operate in the market itself, and then to continue to pay bribes to be able to continue to do business in those countries. And the numbers are just astronomical. I mean, the most recent allegation is that the company paid about $420 million to this official over an 8-year period. And this is just one of the companies alleged to have paid money to her. So she obviously made a lot of money, if the allegations are true, off of this deal.
The total amount of money paid to her was simply stunning. I think I saw a figure, it was well over $1 billion. And I really like the way you characterize that, James, is really this is one more in a series of enforcement actions with these specific actors in Uzbekistan. But for the compliance practitioner, this case also brought, I thought, some really interesting lessons. Most of those lessons were detailed in the settlement agreement and the, criminal plea. One of which was we had the company the business people from the company objected to many of these transactions because there wasn't an appropriate business justification. And obviously that's a red flag, but I was really impressed that from the MTS side, they actually did business analysis some of the corrupt deals they were supposed to be a part of. Kind of how would you suggest a company look at that fact in terms of a red flag?
No, absolutely. That's right. I mean, compliance depends on people like this to raise the red flags and to try to do their job and try to stop these deals. Of course, part of the problem is it went through, and so you need to make sure that there's a way to really put teeth behind that. Just to follow up on one point you made there, Tom, as well, and then maybe we can get back to this, but the U.S. and foreign authorities have actually forfeited about $2.6 billion. So it's just a huge amount of money. And I think, another notable part of this is the incredible amount of international cooperation that went into this case. So obviously you have the U.S., but you have the Netherlands, Sweden, Switzerland, Norway, Latvia, United Kingdom, France, and Ireland, and there are probably others as well. But those are some of the big players that have got together to bring these prosecutions and these asset forfeiture actions, which is also obviously, we've talked about it before, but a very important lesson as well is that anti-corruption enforcement used to just be the U.S., but more and more you're getting this international coalition working on bribery schemes.
James, one of the things I really wanted to ask you about this case was the nature of the defendant's cooperation or lack of cooperation. How would the department or someone in the FCPA unit or the fraud section, or perhaps even you had to face this, deal with a recalcitrant company who's really outside the jurisdiction of the U.S. and how can you persuade them, or how are they persuaded to cooperate at all?
Very difficult. I mean, this is one of the reasons why I think that there are so many. There's so much talk about things like the FCPA Corporate Enforcement Policy that we're going to talk about, I believe, today, and why FCPA enforcement is just a little bit different, maybe a lot different than other kinds of enforcement. Trying to get evidence from overseas, you may have jurisdiction over overseas companies, but actually trying to get them in court here and things like that is incredibly difficult. So you really need to use all the tools available to you, whether that be strong evidence, which is obviously great, some concessions here and there. The international cooperation is really a part of it, to persuade a company that you can't dodge the United States and get off scot-free, that other countries will step in as well. So, I mean, a resolution like this is going to take all the tools in the toolboxes to bring a company to the table. Tom, did I lose you?
Really helps if you unmute your microphone.
Oh, I'm not muted. Sorry. Sorry.
One of the things that struck me is perhaps how extraordinarily difficult the monitor's role or job will be. Not only do you have a company that I cannot tell from the settlement documents that they're committed to this resolution, but obviously they're a Russian company, and he's going to have to be in Russia. He's going to have to deal with a different legal system and different players. And so I was wondering if you had any thoughts on really how does a monitor move forward in that situation, and then what is the role of the department in receiving a monitor's report and or working with a monitor going forward?
No, obviously. I mean, there are different. There are a lot of challenges posed when a monitor is doing work in an overseas jurisdiction. I remember you may recall some of the monitors with French companies from a decade ago, where the monitors had to deal with French blocking statutes and things like that. And then, it hasn't happened yet, but China has a new blocking statute. And what happens if a Chinese company gets a monitor? How do you deal with that in the FCPA context? And Russia is going to be very similar. I mean, not a country that we have a strong law enforcement relationship with. maybe not a country that's going to be particularly favorable for having a monitor there. So it's going to be very, very challenging, and the department's going to have to potentially weigh in and encourage the company to fulfill the terms of the monitorship and or else exercise some of the remedies that it has. But an extremely difficult position for sure.
So, James, let me move to a different area. We had a announcement, or perhaps that's not strong enough, a modification to the FCPA Corporate Enforcement Policy in March, and that really seemed to me center around the issue of de-confliction. And I think that issue still befuddles many compliance practitioners. So I was wondering if you just might be able to talk about what de-confliction is, how it pops up, and what the change was, and whether you think that's going to help that issue going forward.
Sure. So just a little bit of background first. You're right. On March 8th, 2019, the Assistant Attorney General for the Criminal Division announced some revisions to the FCPA Corporate Enforcement Policy. That policy had come out late 2017, so it's been on the books for about a year and a half. In my mind, the biggest change was actually the change to the ephemeral messaging policy part of that, where DOJ had originally said you have to prohibit ephemeral messaging, which caused a lot of problems in the business world, because a lot of businesses, especially places like in China and Brazil, their people used it all the time, and DOJ relaxed that. So to me, that was the biggest part of it. The de-confliction was also a big part of the change as well. The revised policy clarified that when a company that is seeking full credit for cooperation must coordinate or de-conflict its internal investigation with DOJ, and basically what that means is DOJ can, for example, ask the company to not interview a witness and instead let DOJ do that first, or other potential investigative steps that DOJ might think will cause problems with its investigation. It tends to be witness interviews, but it doesn't necessarily have to be. And so the most clear example would be, as I said, DOJ would say, hey, if you haven't interviewed Tom Fox yet, please don't. We want to be able to interview Tom Fox first, and then after we do that, you can interview them. You know, the SFO takes a much stronger stance on this. They say things like, we don't want internal investigations because that's like a company trampling on the evidence at a crime scene. DOJ doesn't go that far, but it does say that at certain times, if you're cooperating, we're going to ask you to stand down on certain things, and you need to do that in order to get full cooperation credit. It can be very challenging. It's not unreasonable for DOJ to ask for that, but depending on the magnitude of the request, the duration of the request, and the like, it can be very difficult to a company trying to do an internal investigation to get to the bottom of what happened, to remediate the problems, if you're not able to talk to the people who were involved or otherwise get to the bottom of what happened. And so there was some, I think there's been some pushback from the defense bar that the de-confliction requests have become too much, too many witnesses, too long of a time. The other issue that's kind of going on in parallel is that this criticism from some of the judges in the Southern District of New York and elsewhere that DOJ is outsourcing its investigations. And the more DOJ says, you can do this, you can't do that, you must do this, you must not do that, the greater risk it will be perceived that DOJ is actually directing an investigation, which can have all kinds of ramifications for discovery, for the perception of judges about what's going on. And so I think part of also what DOJ was trying to do there is to say, look, we're not directing these investigations. There just may come a time where we ask you to not take a few steps, in other words, to de-conflict with us so it doesn't mess up our investigation.
So the next area, James, I want to visit, and this is actually something we visited several times in the past, which is the OECD Working Group Bribery Reports. And you guys reported that there's a Phase 4 2-year follow-up report for the United Kingdom. I was wondering if you might share with us what that is. I know you had experience with that at the Department of Justice, and how really would the United Kingdom use this follow-up report?
Yep. So very interesting. The Organization for the Economic Cooperation and Development has a working group on bribery that deals with the Anti-Bribery Convention. And one of the really unique aspects of the working group and the convention is that there's a peer review process. And it's a peer review process that has some teeth. So a couple of years ago, in March of 2017, there had originally been 3 phases of peer review. Those had already happened. So the OECD working group came up with phase 4, and the UK was one of the first ones to actually go through the phase 4 evaluations. And as you said, this was in March of 2019. They had a 2-year follow-up. And what the working group said is that for the most part, the UK is doing a good job. I think for most observers, looking at who's enforcing foreign bribery laws, I think you'd have to agree that the United States is still number 1, but the UK is probably number 2, or at least arguably in the top 3 to 5. And so the working group said that the UK has done a lot of good things. They praised one of the new laws called the Criminal Finances Act of 2017, and they praised the increased level of and resources for enforcement of the UK's foreign bribery laws. But the working group also said that there was room for improvement. And in particular, the working group said in this report that they were concerned that the, quote, total number of finalized and ongoing cases relative to the UK economy remains relatively low, unquote. And they cite the fact that there is just 3 concluded foreign bribery cases since March of 2017. I don't necessarily disagree with the OECD working group. They do a very good job, but it's also you're criticizing one of the strongest enforcement authorities in the world when it comes to foreign bribery. So yes, obviously they could probably do more and do better, but I think the SFO on the whole does a pretty good job.
Let me turn now to something that, frankly, I'm not sure I scratched my head over, but I was certainly a little bit confused, where the Commodities Future Trading Commission, the CFTC, announced an entry into the FCPA arena. And my confusion was I really had not appreciated that this agency was set up to enforce overseas bribery related to U.S. commodities future trading. So I wanted to get your thoughts on this and maybe enlighten me and some of my other confused listeners.
Yeah, this is a big development, the CFTC's stepping into the foreign bribery enforcement arena. I'm not sure it was a natural thought to anyone, Tom, so I don't think that you're alone in that feeling. But it's not necessarily that they have jurisdiction to enforce foreign bribery laws. It's a little more subtle, and it's that foreign bribery can affect various things that fall within the CFTC's jurisdiction. So, for example, they say that foreign bribery might constitute fraud, manipulation, false reporting, or a number of other types of violations under the Commodity Exchange Act, and thus being subject to enforcement actions brought by the CFTC. And then in their announcement, they give some examples of this. They say, for example, a bribe could be employed to secure business in connection with activities regulated by the CFTC, like trading, advising, or dealing in swaps or derivatives, or to manipulate benchmarks that serve as the basis for related derivatives contracts, and that the bribery itself might alter the prices in commodity markets that drive U.S. derivatives prices. So it's a little bit more of a knock-on effect. Not that they have jurisdiction over foreign bribery per se, but they have jurisdiction over the knock-on effect that might come from foreign bribery. It's very interesting. What basically it means is if you're investigating an alleged foreign bribery scheme, and that scheme involves a commodity, it could be an agricultural product, for example, then the CFTC will likely assert that it has jurisdiction over that as well. And what we've been seeing is that DOJ and CFTC are coordinating, not unlike the way that the SEC and DOJ coordinate. For example, when I was at DOJ, if we would get a self-report from a publicly traded company, we would either call the SEC ourselves, or more likely, we'd encourage the reporting company to do so as well. And I think most companies eventually just would report to both DOJ and SEC if they were publicly traded. But now you see DOJ reaching out to CFTC if there's a commodity involved in the foreign bribery allegation, and CFTC gets involved at the very beginning, much like SEC would do in a publicly traded company case. And of course, there's nothing inherently wrong with that, but it does clearly cause complications for companies that are trying to resolve these, because you have another regulator getting involved, and that always increases the complexity of trying to investigate and resolve an FCPA matter. Now, the CFTC has said some good things, echoing, for example, the piling on policy and some of the other policies that DOJ and frankly SEC as well have pursued over the years. They've talked about trying to coordinate penalties. They will meet with you in the same meeting, so you don't have to have a meeting with both CFTC and DOJ to present the same information. You can meet with both of them at the same time. So I think CFTC does recognize the fact that this causes some additional complexities and burden on companies, but at the end of the day, that is the effect. Companies that are dealing in commodities may have to answer to both DOJ, the CFTC, if you're publicly traded, the SEC, and of course foreign regulators as well. So it greatly increases the complexity of the foreign bribery enforcement landscape for companies.
And James, for our last story on this episode, one that really, to me, emphasizes not only the international nature of your newsletter, but the international nature of the fight against bribery and corruption, where you report that India appoints its first anti-corruption ombudsman. And certainly from where I sit, anything the country of India would do to help move the ball forward in their country is welcome news. But I was wondering what your thoughts might be.
That's the takeaway, Tom. Obviously, India is, I guess in relative terms, it's not horrible in terms of corruption. It's 78th out of 180 in the TI CPI. Still not great. And I think most people who have done business in India or had experience in India have heard stories or experienced themselves that there's a high level of corruption in India. So I agree with you. Anything that India does to try to combat corruption is a good thing. In this particular story, what happened was in 2013, there was an act called the Lokpal Act, and I hope I pronounced that correctly, which authorizes certain parts of India to appoint an ombudsman in order to fight corruption. And that hadn't happened until January of 2019. So almost 6 years went with no ombudsman being appointed. And in March of 2019, the Indian president cleared the way for the ombudsman to take office. This person is a former Indian Supreme Court justice, Pinaki Chandra Ghosh, and I apologize for somebody who myself has a strange last name. For some people, I apologize if I mispronounced that. But he is going to become the first anti-corruption ombudsman in India, and it will be very interesting to see, given India's relatively low CPI ranking but very high growth rate. As we report, India is predicted to be the fastest growing major economy in the world over the next 2 years. So it'll be very interesting to see if the ombudsman can help reduce corruption while still having an economy that's really soaring in India.
Well, James, unfortunately, we are near the end of our time for this episode, but I wanted to thank you for visiting with me. I look forward to continuing the conversation.
Thanks, Tom. Always a pleasure.
Hello, everyone. This is Tom Fox again. I hope you've enjoyed this episode of the FCPA Compliance Report. We'll link to the Morrison and Foerster March 2019 Top 10 Developments in Anti-Corruption newsletter in the show notes. Thanks again for listening to this episode, and I hope you'll join me again next week for another episode. The FCPA Compliance Report is a production of the Compliance Podcast Network and a proud member of C-Suite Radio. Thanks again for listening.